Well, live from the SABC's Auckland Park studios, welcome to this week's last episode of On the Record. Here's what we have on the show for you this evening. National Prosecuting Authority boss insists he's no man's man, including President Jacob Zuma.
I'm not anybody's man. I've never been anybody's man. I'm certainly not there to take anybody's side.
The prison's chief sets the record straight with regard to Abatembu King Buyelekaya Dalindyebo. And in a rare interview with one of the authors of our constitution, Judge Albisex says our constitution, in fact, has most of what we need to solve the land question. It's just that it hasn't been used.
The willing seller, willing buyer principle is not a foundational principle of our constitution.
But first, the SACP tells us why it's going to do everything in its power to make sure that Chris Hani's killer, Janusz Waluś, rots in jail. This after a North Gauteng High Court overturned an earlier decision not to grant parole. In April last year, the Minister of Justice denied an appeal by Waluś. He is scheduled to be released in 14 days.
I feel that we have achieved something in this country where those who have oppressed us in the past are actually talking to us and are showing readiness to negotiate for democratic elections.
Chris Tembisile Hani, SACP and the ANC most revered leader, born in the Eastern Cape, Hani became known internationally after joining the struggle and going into exile. On his return from exile, he continued to be involved in politics as a member of both the ANC and the SACP. But his life was cut short while the country was in the process of negotiations for a new political dispensation, an incident that nearly plunged the country into civil war.
We must not permit ourselves to be provoked by those who seek to deny us the very freedom Chris Hani gave his life for.
Janusz Waluś and Clive Debbie Lewis were sentenced to death for the murder of Chris Hani, but after the abolition of the death penalty, their sentences were commuted to life imprisonment. Waluś shot and killed Hani almost a year before South Africa's first democratic election in April 1993. He sped off in a car from the crime scene that Hani's neighbors saw and took down the number plate. This led to Waluś's arrest. Although he denied being at the scene at the time, police found a hit list which suggested that Hani was third on Waluś and Debbie Lewis' list. With the introduction of the Truth and Reconciliation Commission, Waluś applied for amnesty, but this was denied and he remained in prison. Debbie Lewis was released from prison in June last year after serving 22 years, and now Waluś is also being released. The Justice Ministry says it's disappointed because it holds a different view to how the judge decided on the matter.
We have 14 days within which to make that determination. Unfortunately, the order is to the fact that within 14 days he must be placed on parole and parole conditions should be set. So we'll use the 14 days to make that determination.
There's been mixed reaction to the release. For the family, a painful decision that they have to endure.
When you read that judgment, I don't think she applied her mind. I don't know if she read it at all, because a serious grammatical mistake from a judge. And the conclusion I drew after this judgment was, black life in South Africa does not matter. Black man is dead, and so what? The black widow and her children should move on.
Whilst we have to respect the views of the courts, it must not be forgotten that we are dealing here with a case of a cold-blooded killer. It may perhaps be wise for him to go back to his own country.
To Basotho, that would very much hurt us if this man is released. We don't even want to imagine what would happen to him as a person.
Waluś may have been granted parole, but it seems the matter is far from over. Lehana Tsotetsi, SABC News, Johannesburg.
Well, political parties were quick to react to today's news. Here's what some of them had to say.
In 2 weeks' time, he's going to join a South Africa that he sought to collapse by killing Chris Hani. Now, this release of Janusz Waluś must bring to the center the question of whether Chris Hani's death was in vain.
South Africa is a constitutional democracy. We have laws in this country, and we say that if you comply to the rules, then you must get your parole. And it is a pity that he had to go to court to force the minister to get his parole.
There are processes that need to be followed. In our understanding of this is that the processes have been followed, that there has been an application made, that the court has now ordered that parole be granted, and our view is that under the circumstances, Mr. Waluś must now be released on parole.
It is a travesty of justice. It is lugubrious that a month before we commemorate the assassination of one of the great leaders of our movement, he is released on parole. Our view is that on his release, he must be deported to the country of his origin and never come back to South Africa again, because we think that it is insensitive to the devastation caused by the murder of Chris Hani, not only to the ANC, the Communist Party, but to the Hani family.
Well, the ANC will, of course, be granted that wish. That's if, though, and a big if, those that are planning to challenge this decision are unsuccessful. I did catch up earlier with the Correctional Services Commissioner, who said this is what will happen in the event indeed Janusz Waluś gets released in about 14 days' time or so.
What will then happen is for the Kgoshi-Mampuru Correctional Services Parole Board to look into the award in consultation with the Minister of Justice and Correctional Services, and then thereafter is for us to then set out conditions for his release. What is important with Waluś is that he's not a South African, and therefore due consideration shall have to be made with the Department of Home Affairs, so that if he has to be then handed over to where he comes from, that can then be done with the assurance that he will comply with these conditions as he's in that country. So we then have to looking at what bilaterals we have, whether we can then send him over. So it's going to be sort of problematic in that sense, but we will definitely, if it is the belief and agreement by the ministry as well as the parole board and my legal team, if that is the award, we shall implement it.
So there's still a process to be followed?
There's absolutely a process to be followed.
It's not going to go just yet?
It can't just go just as yet. We have to look at all of those that I've mentioned. He's not a South African in the first place, and we can't release a person on parole where we will not have an assurance that he will comply with these conditions in the other country.
Well, one man who's going to be on the driving seat of a campaign to make sure that Waluś doesn't go anywhere but stays in jail is, of course, the Deputy General Secretary of the South African Communist Party, Solomon Paila. Welcome, sir. Thanks very much for joining us.
Thank you very much, Will.
Well, if the social media is anything to go by, people are asking, why is the SACP holding such a grudge?
It's not a grudge. We're actually following the law. In fact, many people who have spoken here have not deeply followed the process, including the actual process of the parole. And that's the issue that we're taking up. That's why we feel that there are huge prospects for successful appeal. Because in the first instance, you'll remember that after this callous murder of Comrade Chris Hani, the TRC refused to grant both Clive W. Lewis and Janusz Waluś amnesty on the basis of lack of full disclosure of the truth. So that was the first point. Secondly is that they were sentenced to death, which was commuted, on the basis that the trial judge actually, which is a major consideration when there is parole application, which in this case, the judge erred, and we want to contest that is an area that we want to look into. The trial judge actually indicated that the murder was premeditated, meaning that it was properly planned, and the murderer, the murder was cold-blooded. And thirdly, that the man they murdered was defenseless. And he said, in that instance, the court must impose the harshest sentence possible. And that's why they gave them death sentence. So when you review that on the basis of our democratic dispensation to get to commute there to life sentence, when you come to a parole process, you must also take into account that harshest sentence consideration by the trial judge, which in this case has not been followed. Secondly is that in the process, you need to have what we call victim-offender dialogue as a process towards considering parole. Now, this process was not actually even done. In fact, to our dismay, we found that the judge opportunistically uses Janusz' letter to try and initiate a victim-offender dialogue with the Hani family, which he did when we went to the parole court hearing, and at that time he indicated that the intention to talk. The Hani family said through Ms. Hani, Dimpo Hani said, that's okay, but do it legally according to the process through our lawyers. And then he sent a letter. At the time that he sent the letter, Ms. Hani was in Cuba. When she came back, we showed her the letter that he had made this particular request. But we actually realized that he had made the request not for the process of victim-offender dialogue, but so that he could qualify that he had initiated a process of remorse through the application. So it was a mechanical thing. Because when she responded to that, she said, well, that's okay, but can he answer the following few questions? We drafted them questions to say, answer this question, that would then facilitate a victim-offender dialogue process, which he never answered. To our dismay, we see some of his letters are attached in the court judgment, completely unacceptable. In fact, in this regard, we're not even asked, these were not part of the initial documents. We really feel that this judgment was completely misguided, off the mark, and I think that the insensitivity of the judge was actually displayed from the beginning when she actually said to Ms. Hani that she thinks it's now time to move on. We want to say we have no problem of moving on, provided there's the whole truth. History will never know what happened to Chris, except that he was murdered by, through the collaboration of these two individuals. There were many leads, including which the TRC said, actually, if it was given enough funds to proceed, it would have continued to investigate. And that was never done, for instance. Let's just take an example. The weapon that killed Comrade Chris. Lewis was a member of parliament based in Cape Town. He had procured the weapon. Where did he procure the weapon from? There was a hit list found with Janusz Waluś, who drafted the hit list for him. It was inconceivable that he could sit down and have all the determination of who to target, who to eliminate, and so forth. So all of those things are issues that because they fail to disclose the truth, they will actually go out with them. In other words, if he was to respond to those questions, in the questions that you've highlighted, we'd be talking a different story today. Yes, the family will be looking at it in a different way, including the Communist Party. We'll be able to know the truth and move on. But the judge, in this case, creates an impression that actually parole is a right. And actually, we must say, parole is not a right. It's a privilege that is accorded to prisoners who undergoes a particular process in jail. And in the process, they must show remorse. And in this case, there's been disdainful attitude to the family, no remorse at all. What do you then to say, to those people who say, look, there are literally thousands, if not tens of thousands of South Africans who are really in the same boat to a greater or lesser extent, who don't know what happened to their relatives, who would have wanted to have gotten closure, but they've had to accept that certain things may have been solved, or leads may have come through, and people may have been able to at least have some idea of what would have happened. But there are thousands of others who actually still do not know what happened to their fathers, their mothers, their brothers, their sisters. And but we are prepared to say, you know what,
let's move on, let bygones be bygones. And we're not talking here about white people, as Mrs. Hani said, black people who suffered just like she did, but who feel that perhaps it's time to move on.
Well, at this point, we don't deny that there will be people like that, but in many instances, they will not know the killer. Or if the killer is there, the killer would have, the court process would have proven why the killer was guilty and so forth. But in this case, the truth did not come out. That's a critical area. On the one hand, I think let's try and also be sensitive to families, individuals. People react to trauma differently. And I think that we have seen that some other people live with trauma for life. Sometimes it's unable to go. And I think we should not impose it on people. Let people deal with it the way they feel it's appropriate to deal with it. But for the court to use emotion, to impose emotions on the legal proceedings, it's wrong. Because actually, it's an abuse of the court process. But I think we would not necessarily talk for Ms. Han in this case, but we really feel like her, that she's deeply emotional at this moment. And you can see all the time, even when the judge actually said that she must move on. And she felt that the level of insensitivity, indignation, in fact, she cried in court. This is how deeply she still feels about this particular matter. So you can't go to such a person and then say, look, move on. Well, the perpetrator lives freely. So in this case, the victims, the onus is on the victims to prove the move on. But the perpetrators, they just are given freedom, all the freedoms they enjoy, but we don't care much about the victims. I think it's an area that must be addressed, including for all others that they've not been found.
Now, what's going to happen next? What are you going to be doing as the SACP?
We've already instructed our lawyers to read deeply into the judgment and to advise us of the prospects for appeal, which we believe at the moment that there are huge prospects for successful appeal. And I think that equally, the Minister of Justice, I heard him indicating that they are going to read the judgment and they are considering appeal. As you know, the court gave us the right to enjoin the process, so we'll again enjoin the process to appeal, and we'll encourage them to do so.
Mr. Mpaila, thank you very much.
Thank you very much.
For joining us, Mr. Sweli Mpaila, who is the second deputy secretary of the South African Communist Party. That, of course, being the story to watch over the next 14 days or so. We're going to take a quick ad break. After the break, my one-on-one with the National Director of Public Prosecutions. Don't go away.
The big news is Newsroom.
We also stream live on YouTube.
Whether you're at home, at the office, or at the gym, wherever you are, Newsroom is right there with you. Bringing you all the latest news, updates, sports, weather, and everything in between. Get all the latest news you need on the go via live streaming on our YouTube channel. That's Newsroom, weekdays at 9 a.m. only on the SABC News Channel.
NPA Chief Sean Abraham says rubbished claims that the agency is in tatters, saying it is mischievous to politicize the National Prosecuting Authority. I sat down with him this morning on the sidelines of a two-day conference that his agency has organized together with other crime-fighting institutions, among them intelligence, the police, as well as correctional services. I started off by asking him what were some of the challenges he has had to contend with after taking up the position of National Director of Public Prosecutions.
It was always going to be extremely difficult to do so coming in. What favored me largely is the fact that I was very mindful of the history of the institution. and having a certain idea or vision of where the institution needs to go to in being the cornerstone of justice to society and fulfilling its legislative and constitutional mandate. And of course, the difficulty of regaining the public faith and confidence in the National Prosecuting Authority and in the administration of justice generally.
I mean, you are very much an insider, and I get your point about the difficulty you're having in having to say some of these things in public. But some of the allegations, you spoke about some of them during your opening or your welcoming remarks this morning. I mean, some of them are things that are out there. The perception that you took sides in what were essentially political battles. The assertions or allegations that someone like you is in the position that you are in because you are someone's man, the president's man, to be more specific. So it's those things. Were those things, or are those things really true? And are those some of the things that actually took the NPA to a point where the public had a problem with it, and the public's confidence in the NPA had gone out of the window?
Yeah. I completely understand your concern and the issues that you raise. I think it's crucial for me to state at the outset, I'm not anybody's man. I've never been anybody's man. I'm certainly not there to take anybody's side. It's rather unfortunate that a so-called statement was made, or to the effect that I've chosen sides or that I'm somebody's man. I think you can look at my entire career and see that I was a prosecutor. I've never been a politician. I've always been an astute prosecutor, upholding the rule of law. I think one has to look at it in the following light. When I came in, I made changes. These changes were for the betterment of the institution, to take the institution forward. The results currently speak for themselves. It was about treating people fairly, eliminating any degree or possibility of the abuse of powers. You would appreciate, and I'd want the viewers to appreciate, the powers that a prosecutor has is so immense. It affects people's lives. It affects their careers, that of their families, that of the villages, towns, or cities that they live in. It's a discretion that should be exercised with the greatest degree of caution. I was very mindful of the so-called internal politics within the NPA. And for me, it was always about fairness and equality. And that's why I've invited anyone and everybody to make their own observations in the institution.
So what have you done? What have you put in place to make sure that the mistakes of the past are never to be repeated?
I think it wasn't really a matter of putting things into place. I think it was looking at the existing structures and resources that were there, shifting resources and structures around a bit to obviously enhance service delivery of the institution. None of my deputy national directors of public prosecutions have powers to institute prosecutions in any matter. They derive those powers and that authority through me in terms of the Act, should I delegate such an authority or a power. So there's this complete misnomer that some of my deputies have prosecutorial powers and make decisions. None of my deputy national directors have the power to do so. I've not delegated anybody with such powers. In fact, they categorically know they don't have those powers.
Now, with everything that you're saying you've done to turn things around, with all that you found and tried to correct, the goings on now, do you think they're going to affect or undo what you had already put in place up until now in any way? We're talking about the cases that are in the courts as we speak.
I can't see a situation that, that whatever decisions have been made in the institution, can be undone. I think we mustn't lose sight of the fact that these matters are in court. We have checks and balances in the criminal justice system. Ultimately, if a matter goes to trial, there are appeal processes, there are review processes in the case of irregularities or alleged perceived irregularities. Matters can go all the way to the Constitutional Court on appeal. It's a good thing that we have due process in this country. What's extremely disappointing is to learn how sectors of the media, of course I'm not saying you're one of them, but sectors of the media has portrayed decisions made by the institution as having been politicized. I will never allow political influence and abuse of political power in the institution. I'm too mindful of the sanctity of that office and how crucial it is for society to know that when the NPA make decisions, that those decisions have been made with due regard to the facts, the rule of law, the proper administration of justice, the interest of society, and what the interest of justice best dictates. There are various factors that one takes into consideration ultimately. But I can assure you there's been no abuse of political power. There's been no political influence. When I was appointed specifically because of my experience. Because what I could bring to the institution in taking the institution forward. I think everybody knows we've had people from outside, and with no disrespect to anybody. I'm a career prosecutor. Why would I want to jeopardize my career, my integrity, for any degree of influence? It's about justice. It's about justice to the people of this country. The work of the institution will speak for itself going forward. And only time will tell. Only time will tell.
Now, you said in your speech at the opening of the conference, in fact, you asked a few questions. At what expense is this to the NPA and to our constitutional mandate? What does it how does it impact on our moral standing and on our ethos, the NPA that is? I want you to answer those questions yourself.
It's specifically about our vision and mission and our service to society. It's about not having a tunnel vision mentality, but looking at matters in isolation and not looking at the broader scope of investigations. I don't ever want a situation in the NPA to arise where any person is targeted. And that is exactly why I ask those very hard questions. To ask officials to have some degree of self-inspection and or reflection. And that's why I ask those questions.
You're declaring war on crime, organized crime, and corruption. The question is, what are you going to do?
We've always had dedicated components in the various offices of the directors of public prosecutions throughout the country. I'm looking at a more permanent structure to be able to render the necessary service and assistance to the Directorate for Priority Crimes Investigation. That's specifically why we facilitated this workshop today. You'd recall, I tried to systematically go through the legal requirements and the legal provisions to remind the various institutions of what the law envisioned their responsibilities would be. And ultimately, it's for us to work in greater synergy to be able to achieve better results. Organized crime has an immense impact on the fiscus of this country. It has an immense impact on destroying societies. We need the public to play a crucial role and a more active role in providing support to law enforcement authorities to eradicate serious organized crime and corruption. We cannot do it without the community. They are our witnesses. They are our complainants. They are also the victims of crime.
By putting a lot of emphasis on cooperation between, the police, the prosecutors, intelligence, and so on, is it because you sort of got a sense that some people may have departed from what are essentially their core responsibilities, constitutional obligations more specifically?
I think it would be wrong for me to say that they've departed from that. The purpose of this workshop was specifically to understand where did communication go wrong? Why aren't we acting in synergy? If we act in synergy, we can achieve so much more as a collective. We respect your legislative and constitutional mandate. We don't want to usurp your responsibilities. But ultimately, we are here to help. The earliest you get us on board, or the sooner you get us on board, the better. The better for the administration of justice, the better for the rule of law. The quicker the public will regain confidence in the administration of justice. It's about reminding institutions that they too are accountable. That the Constitution demands this from each and every one of us.
Now, you ended your remarks by expressing your deepest condemnation of what is going on at universities at the moment. But you went further to say the people responsible for what you call the anarchy at universities are not students.
I said not all of them are students. I've been advised to that degree by our investigative structures. Of course, my office will be approached for guidance in respect of these matters. This is a matter of national concern. It's affecting the security of the country. It would be irresponsible of law enforcement just to allow it to continue in the manner that it has.
What other forces could possibly be at play in a situation like we are seeing at the university?
You know I cannot speak about it in public. These are matters that are under investigation.
I'm not a lawyer and a prosecutor.
I cannot. Unfortunately, I cannot comment it. The matters are subject to investigation, and once those investigations have been concluded, they will be dealt with appropriately. I think we'll be directed by the evidence at the end of the day.
Could it be political, as some people have suggested, political infighting within and among organizations?
I cannot answer that.
Advocate, thank you very much.
It's a pleasure. Thank you so much.
Thank you.
Thank you.
Well, we'll definitely be watching that space. Well, I also caught up at the same conference with the Commissioner of Correctional Services, who spoke or set the record straight, as he preferred to put it, around the issue of Abatembu King Buyelekaya Dalinyebo. But I began by asking him what some of his major challenges were. That interview after this short ad break.
Manor produces abstract and symbolic works of art. He called his latest collection Vote with Ink, Not Blood.
Praying for peace, literally, in my own way.
The South African film titled Luister or Listen in Afrikaans tackles issues of race in the country.
I think that the end goal is the reformation of institutional culture, but how we get there is in fact through changing the language policy so that no student is forced to learn in Afrikaans.
It's fashion designers like Julia Mpoko who are starting to pay more attention to menswear and hope to make a mark in the fashion industry.
So regardless of whether you're African, European, there's certain styles that you like. So if an African man enjoys wearing simple, well-tailored pants, then yes, I guess.
Join Refulo Mula for that 1 hour weekly dose of arts and entertainment news every Friday at 9 p.m. on Trends.
What would you say is your single biggest challenge at the moment?
My single biggest challenge in correctional services actually is the function of management, especially bringing a common approach to correctional services managers throughout the country and making sure that the objectives that are set out we all are eager to achieve. Along our evolution, it has happened that there's never been any consequences for mismanagement. That's what I'm putting in place right now. But also a uniform approach by the leadership of the department to root out corruption and maladministration. If that is going to be our common goal, Department of Correctional Services will turn the corner faster than it is going to be a sole crusade by myself. So what I'm trying to do right now is to ensure that at my level, at the level that report directly under me, that we have this common approach, and I do believe we shall achieve the goal.
How widespread is maladministration and corruption?
Because we are operating in terms of regions. From region to region, there are these instances of maladministration, and largely with regard to procurement, and then secondly with regard to human resource appointments. That's where mostly we have this. In terms of correctional centers operating, yes, from time to time we have these breaches of security, sometimes where an offender is released without having due consideration as to whether it was his time or not. And now that in itself is what I'm gearing myself and the team to work against. And once we have the common approach, as I say, it will be very easy for us to turn the corner.
People find it difficult to connect or to look at how, for example, people they know who are in prison are able to call them, get messages to them and get stuff sent to them and that sort of thing. And you compare, contrast that with someone like the Batembu king, you know, who has problems with the clothes that he's supposed to wear, or even get visits, you know, from people from chiefs from the kingdom and so on. To lay people out there seems to be inconsistency in the way these issues are managed.
I think one needs to really be in the environment to understand how we function. And much as we try to educate members of the public, it does sometimes happen that our education drives do not reach those that we think it's supposed to reach. Privileges of your sentenced offenders differ from the classification group in which they belong. You find out you have what we call your maximum. Maximum is a person that has a long sentence who has been convicted for having committed serious crimes like your rape, your murder, and as well as your robbery. And whereas your medium classified are those that have done largely your economical crimes. And therefore, the privileges then differ as well. Find that those that are in the medium category enjoys more privileges than those that are in your maximum category. Now, we from time to time have high-profile offenders, inmates in our facilities, like the King, as you are referring to him, who comes at a point where he's of the opinion that he's not supposed to be in prison in the first place, and secondly, that why then should he conform to the rules and do what is expected of him? So he's a person that is in serious personal uncertainty himself and his own challenges. And we're trying everything in our power to make his stay in our facility as comfortable as we can, in the sense that what are then the rules that pertain to him? So he has steadfastly refused to put on the orange uniform, and our officials are saying, but you will have to put it on. Together with his family and also those that are working in correctional facilities, or psychologists and social workers, are currently busy putting programs to him that would cause that he has insight into his offending behavior. And up until that stage, we are confident that the treatment that we are according him is correct. It is in line with our policy. He's allowed to have a PT pen. He's allowed to have a sweater, as all other offenders are allowed. And I'm comfortable where I'm sitting that he's been given those privileges. But there is this other human factor that I think one needs to also put clear, in that officials, as much as they know what are the rules and the prescripts, there are those that sometimes ignore the rules and allow for other privileges that are not within the rule book. And those are that give us then the challenge to say that, but you are not treating all offenders equally. In our case, in our approach, all offenders that have been sentenced and those that are on remand should enjoy the same privileges, depending on their classification, of course.
And how much of that could have something to do with maybe impropriety, corruption among members of correctional service officials?
Well, I think we should see what is happening in our communities, in the general public, as that can also happen in our correctional facilities. Corruption is happening outside and inside our facilities as well. We have apprehended officials who have brought in cell phones, who have brought in contraband for offenders, who sometimes also bring in even clothing. Sometimes there are those that have smuggled in guns into our facilities. And it would not be correct for us to then say that this corruption does not happen in our facility. It is happening. And we have then to work with the other crime-fighting agencies, especially where we are today, where all of us in the criminal justice system and cluster have converged here to come and say, but how do we collaborate? How do we get support from one another in fighting organized crime?
On to another story that we've been tracking for you for weeks now, and that is the story around the land question. Well, a few days ago, one of my colleagues had an interview with a retired judge, Albie Sachs. But just to take you a step or two back, to give you a bit of context to what we're going to play for you, let's go back to something we played for you last week, and that was President Jacob Zuma addressing the House of Traditional Leaders.
Can we address poverty, inequality, and unemployment without addressing the land question fundamentally? I don't think we can. Therefore, the issue of land has been a problem perpetually. Much as we say we needed to utilize the land in the areas of our communities, but the reality is what used to be referred to as the 13% that we owned, the population in those places, which used to be called reserves, has grown and the land has not grown. As a result, in many areas, we are almost, the settlements almost look like townships because they are now crowded. There is no space. The land does not grow, but the population grows. We need to have one serious legal firm that must represent all of us. Have one approach is to actually to deal with this issue in some details. The very law that we have today to claim is lopsided against the black people. Very difficult for you to prove that this land belonged to your ancestors. Very easy for a landowner to say you can't get the land. That's how the law is. But another question that is important for us to ask is a life and death question. Because if we talk about poverty, if we talk about inequality, unemployment, the bulk of those people are black people. And it emanated from the land dispossession. Was the decision to make 1913 the cutoff date correct? Perhaps yes. But was the land taken in 1913? I believe in percentage-wise, the land taken after 1913 is very small, very insignificant than the land that was taken 1817 in the main, particularly 18-something. That's when the biggest chunk of the land was taken. 1913 was legalizing the land that had been taken. It was a consolidation of the colonization of South Africa. So all what we are fiddling about, a small percentage where they realized that there was some fertile land here we did not take, and then removed people there. The bulk of the land and the defeat of many of our people was in particularly 18. I could forgive the period before to be reasonable. It's a matter for us. We cannot keep quiet and die as we did when we were oppressed. It's a matter we need to raise and discuss and find a solution. I believe, as a son of a black man, being black, being on my own, as always, that we need to shift that cut-off date. But you need to find a reasonable way of addressing the issue within the Constitution, within the law, but look at the facts.
Well, one man who was involved in the evolution of our Constitution, he was one of the co-authors, in fact, of our Constitution. Former activist and now former constitutional judge, Judge Albie Sachs, just saying, take into account some of the points that were raised by the president there. The fact that the land hasn't grown, that the law is lopsided, as the president said, that 1913, whether 1913 was, the right cut-off date, and whether, in fact, we're not fiddling with this small percentage. But at the end of the day, as the president said, we have to look at the law. Well, from where Judge Albie Sachs sits, the Constitution actually has a lot, most, if not all, the answers that we need in resolving the land question. Here's what he told our colleague, Tebogo Alexander.
The sunset clauses set with the sun they were just temporary. It meant people in the civil service couldn't be dismissed immediately. And we needed it. There would have been chaos in this country. The railways couldn't run, the post office couldn't run, electricity wouldn't come there. It would have been a disaster for us. And reactionaries would have been only too pleased. The people who assassinated Chris Hani, that's what they wanted, a breakdown. So the Sunset Clause was simply a kind of a guarantee that labour law principles would apply to people in employment, and there would be a staggering transformation of the civil service to bring about, through affirmative action, changes and so on. So that's not the big issue. We had a government of national unity, but that was for 5 years maximum. And in fact, F.W. de Klerk pulled out after 5 years. So that's out of the way. The third element that people refer to is the property clause. I wish they would actually read the Constitution. I'm not saying this now to be superior to anybody. We fought more over the property clause than any other section of the Bill of Rights. It's a long clause. It does not entrench property rights. It only entrenches a right not to be arbitrarily deprived of property. B, it includes a number of clauses that impose a duty to restore land that was taken away under racist statutes after 1912. And we've had something like 80,000 cases of claims where property has been restored. But the huge transfers of property, seizures took place in the 19th century. So then we have sections on land reform. And the need for land reform is in the Constitution. And the duty on the state to promote land reform is in the Constitution, in the property clause. Then it goes on to say that if land is expropriated, it will be permissible to expropriate property for land reform. In America, you couldn't do it. In America, they have a takings clause, and if it's for land reform, no, you can expropriate property for a school or a road or public purpose like that, not land reform, that's politics. In South Africa, we have a clause that says you can expropriate property for land reform that is in the public interest. And then it goes on to say, and this is, I see it so often said, willing seller, willing buyer. Those phrases do not appear in the Constitution. The Constitution said if land is expropriated for land reform or any other public purpose, then there has to be compensation, which must be just and equitable. And in deciding what's just and equitable, a court will take account of, and it says the history of the acquisition, I think it's the benefits and the use that the land's been put to, and market value. It's not just market value, it's only one factor. And one reason we accepted that clause was we were very aware I won't mention a country by name, but there was one country where a top leader of the national struggle for freedom had spent 6 years in jail. He went on to become president of the country, and not long afterwards he started seizing farms. Whites expelled, he took over the farms himself. His family became super rich. We didn't want that in South Africa. We didn't want the people to be able to use the state, to capture the state for self-aggrandizement and self-enrichment. We wanted judicial control. We didn't want the state deciding itself when it's appropriate. We wanted to avoid that. That's why the clause is so carefully calculated. But the willing seller, willing buyer principle is not a foundational principle of our Constitution. And it's never really been tested in the court. There have been hints from the Constitutional Court that the issue is still open for discussion. So don't blame the Constitution. Use the Constitution.
Don't blame the Constitution. use the Constitution. Well, that's all we have time for on tonight's episode of On the Record. From me, Vuyo Mvoko, and the rest of the team, it's a good night, but do join us again next week on Monday.